Everyone. Today we are having a video lecture on intermediate paper number 5, Business Law and Ethics of CMA Inter. This will be a video lecture where we will be discussing each chapter from a examination point of view. You are aware the best way to prepare for examination is to go through the study material from beginning till end. But students normally prefer to have a method where we will cover the chapters in most brief time span possible with most relevant topics. While doing this, there is a possibility topics which has not been considered in the lecture may also come in the exam. But it is always preferable to prepare for examination considering the previous examination pattern. In such a manner, we are proceeding with the video lecture. So, first, we are going to consider one of the most important chapter with most weightage, Indian Contract Act 1872. Indian Contract Act 1872 is the governing act as far as contracts are concerned. So what is a contract? What are the essential elements for a contract? Contract, as you are aware, you can go through the definition. But to constitute a valid contract, what are the essential elements? Fundamentally, there should be one offer and there should be an acceptance. Also, there are other elements like consideration. Coming forward, you will discuss all these things. But most importantly, as far as a contract is concerned, fundamental thing is there should be an offer and there should be an acceptance. So, one of the most important or repeatedly asked question in an examination point of view is, as per Section 10 of Indian Contract Act, there are certain elements which are required to constitute a legal contract. These points everybody should be aware. Perhaps one of the most repeatedly asked question, what are the essential elements for a valid contract? Also, there is another possibility. You may be given a scenario or a case where you will be asked, considering the scenario, is this a valid contract? Only if you know these essential elements, you will be able to identify whether this is a valid contract or not. So let us proceed. What are the essential elements for a valid contract as per Section 10 of Indian Contract Act 1872? There shall be an offer or proposal by one party and acceptance of proposal by other party. So for constituting a valid contract, there should be an offer and there should be an acceptance. Mr. A should offer and Mr. B should accept. When there is an offer by one party and acceptance by the other, we can say there is contract. This is the first point. Second, there shall be a legal intention. There shall be an intention to create a legal relation and or an intent to create legal consequences. What does it mean? Mr. A enter into a contract with Mr. B to supply some drugs, illegal drugs. So will it be a contract? So Section 10 of Indian Contract Act says There shall be an intention to create legal relation and intent to illegal consequences. Only matters which are legal can be considered for contracts. So, point number one, there should be an offer and acceptance. Point number two, there should be an intention to create legal relation. Point number three, the agreement shall be supported by lawful consideration. This is one of the most important point. What is a consideration? Consideration means something in return. Students should always bear in mind. Sometimes they will be aware of the concept, they would have written in the exam, but when the marks come, they will not be able to get, will be able to see. It is because, as far as an invigilator or a person who is checking your question paper is concerned, he or she will look into the question paper and want to find some key terminologies or words which are which should be present in your answer. So this word, offer, acceptance, consideration, legal relation, these are key words. Unless and until you are able to use these words in your answer, you will not be able to score. If you are using any synonym or meaning a word that is having similar meaning also, will not give you the appropriate marks. So these are all key terminologies which you should be aware or keeping in mind. So consideration, what is consideration? Consideration you should keep in mind is reward or remuneration or something in return. So everybody, what is consideration? There is some only one definition, something in return. You should always keep in mind. So for an essential element of contract, there should be an offer, acceptance, and a consideration for creating a legal relation. Third, the parties to the contract shall be competent to contract. This is another important. So, Miss one Master A, aged 10, enter into a contract with Mr. B, aged 70. Is it a valid contract? So, only a major person can enter into a contract. Otherwise, only a person of 18 years plus are competent to contract. Okay. So, competent to contract. Or suppose Mr. A, who is in a bar drinking some alcohol, enter into a contract with Mr. B. Is the contract valid? No. He is not in sound mind. The person is not competent to contract. Competency of contract is essential. What is the next one? There shall be free consent between parties to contract. What is free consent? Suppose I show one knife to you, to Mr. A. He's pointed one gun or a knife and asked to enter into contract with the Mr. B. Is that contract valid or legal? It is not. It is not having free consent. Free consent means the willingness or without being coerced. These are all keywords we should use. What is opposite of free consent? Opposite of free consent is coercion. Coercion or compulsion or forcefulness. So there should be free consent. He or she should not be forced. So there should be free consent between parties. Next is the object and consideration of contract shall be legal and the same shall not be opposed to public policy. These are all same. It is similar to this point only. It means contract should be legal, it should not be illegal, and it should not be opposed to public policy. The terms of the consent shall be certain. The terms of the consent shall be certain. That means something that is uncertain or may not happen. That is not contract. May or may not can be contract. something that is not at all possible, or which is not even in the knowledge. If there is uncertainty, it cannot be contract. For contract, there should be certainty. And lastly, and most importantly, the agreement is capable of being performed and is not impossible of being performed. So I am telling Mr. A will give moon to Mr. B. So that contract is not valid because it is impossible. So these are the essential elements for contract. One should be very well aware of this point. All this point is under Section 10 of Indian Contract Act 1872. So we will see some scenario, apply some practical. Question can be direct also. When it is asked direct, you will be asked what are the essential elements of a valid contract. You can answer these points. Or indirectly, and most probably that way only in the examination they will ask. So what is it? We'll see some scenario. Mr. P, aged 11, enter into contract with Mr. B. Is it a valid contract? No, because minor cannot enter into contract. There is no competency. Where is the point? Competent. So, competency. Mr. A enter into contract to sell his car worth 1 crore to Mr. B for 1 rupee. For 1 rupee, Mr. A is selling his car. Is it a valid? Question. The answer is yes. Consideration need not be adequate. Even if it is 1 rupee, if there is consideration, it is valid. If there is no consideration, it is invalid. Okay. Not to confuse you, just to say this is between strangers. Suppose a father is giving gift to son. Is it contract? Consideration can be love also. Father gifting to son out of love can be consideration. But there are all exemption. This you don't need to confuse. Normally, between two strangers, there should be consideration. Even if it is 1 rupee, there should be a consideration. Next, Mr. B was shown a gun to enter into a contract with Mr. A. Is it valid? Because there is no free consent, it is not valid. Mr. A and B entered into a contract, but they are not fully certain about what are the conditions for completion of this contract. Is it valid? Since it is not certain, it is invalid. Mr. A enter into contract for 1 crore rupees with Mr. B for selling marijuana or drugs. Is it valid? No, it should not be illegal. There should not be illegal. There should be legal relation. Mr. A enter into a contract for giving something that is impossible. Like, for example, he told he will give Mars to Mr. B. So something that is impossible cannot be entered into contract. In such a way, you should study the concept with full clarity. In such a way, if a twist and turn is there, you should be able to identify. So next, void and voidable contract. What is void? What is voidable? Void means, so you are aware, something that is not valid, that otherwise invalid. Void means invalid. What are the void contracts? What are the different kind of void contract agreements? Different. The following are the different types of void agreements. If consideration and object are unlawful in part, agreements without consideration, agreement in restraint of marriage, agreement in restraint of trade, agreement in restraint of legal possession, agreement void of uncertainty, agreement by wager. These are all void. This you can no way make it legal. Void agreement are not legal. There is a difference between void agreement and illegal agreement. An illegal agreement means much more serious than a void agreement. Both are not legal. Illegal agreement are more severe in nature. What is voidable agreement? An agreement which can be void at the discretion of one person. Suppose an agreement, suppose a Mr. A entered into an agreement with Mr. B and he was not able to satisfy some conditions. So that agreement become voidable at the option of Mr. B. He can choose to make it void, he can choose to make it valid. An agreement which can or cannot be void is called voidable. We're just discussing the concept. You should be aware of these topics. Different types of agreement. Agreement in restraint of marriage, agreement in restraint of trade, agreement in restraint of legal proceeding. These are all voidable contracts. Consideration. Consideration means something in return. As we discussed, for a valid contract, there should be offer, acceptance, and consideration. Without consideration, there is no contract. I would suggest students after the chapter is discussed, there will be another video discussing the important questions from these chapters. It will be a single video. You should go through that video to identify what are the important topics. One should be minimum having knowledge regarding that questions. Minimum, you should be aware of that questions. So this is a video. We are trying to cover the video in short span as short as possible. So contract and decontract essential elements are same. Earlier we discussed 10 essential elements as per Section 10 of Indian Contract Act 1872. Same apply for e-contract also. Hmm? Offer should be there, acceptance should be there, lawful consideration, legal relation, certainty, competence, genuine. This we discussed. Competency to a contract. Who is competent? Who is eligible to contract? We can. So the more simple thing is to know who is not competent to contract. One should be aware of these things. Okay, this is important. A person who is not major. Major means who has not attained the age of 18. Who is a minor cannot contract, enter into contract. An unsound mind person. What is unsound means? A person having not sound mind or mentally not stable. That person is not competent to contract. A person who is disqualified from contracting by any law, some law. Suppose some law has made a person not eligible to contract, the person also not eligible to contract. So this is important. So the suppose Mr. A who is adjudged insolvent under Insolvency Act or some act, is he eligible to enter into contract? No, he is not competent to contract as per Section 11. So a minor, an unsound mind person, or a person adjudged as per any law is not eligible to enter into contract. These are all detailed discussion on who is a person of contract, illustration. So we discussed the 3 points regarding disqualification for entering into contract. There are other people also who are disqualified. Who are they? Alien enemy. Who is an element, alien enemy? So at certain times, our government can declare some parties as our enemy, enemy country, alien enemy. These are all terms declared by our government. So in such a period or a time, one should not enter into contract with that party. For example, in an Indian point of view, Pakistan some can sometimes be declared by government of India as alien enemy. So an Indian entering into a contract with Pakistani at such a point of time will be considered an invalid contract or void contract. Hmm. Foreign sovereigns or ambassadors. There are certain rights for these people. So we are not able to sue or legally move against ambassadors or foreign sovereigns. So these people, foreign sovereigns or ambassadors, convicts who has been imprisoned, insolvents, company or statutory bodies. Okay, these are all other disqualified people. You should be aware of this. This is one of the most important. So earlier, as per section 10, we discussed from essential contacts for entering into contract. One is free consent. Otherwise, opposite, there should not be any coercion. Hmm. This terminology you should be able to reproduce. Unless you are able to reproduce the same word, you will not be able to score. Free consent, opposite coercion, these are all terms you should be able to use. So, what is free consent? If it is not caused by coercion, undue influence, fraud, misrepresentation, mistake, it is called free consent. I'll tell you. Mr. A show a gun to Mr. B to enter into contract. That is coercion. Using force is called coercion. Mr. A is the father of Mr. B. Using that father-son relation, he used his son to enter into an agreement. So that is use in bad use of influence. So it is called undue influence. Using of improper mean of using influence. It is called undue influence. Fraud, you may be aware. Cheating is called fraud. That is fraud. Misrepresentation. Misrepresentation is a wrongful representation of fact. One should be aware of what is the difference between fraud and misrepresentation. It is a possible question in exam. Difference between fraud and misrepresentation. Misrepresentation, fraud is serious than misrepresentation. It is a more crime. Fraud is more crime compared to misrepresentation. Mistake. On our, you will be aware of what is mistake. So free consent is said when if it is not concerned with coercion, undue influence, fraud, or misrepresentation. You can go through the chat. So we already discussed what is coercion, undue influence, father son. Other relation are the doctor patient, advocate, and plaintiff, like that. Fraud, misrepresentation. In this, my suggestion is you should be aware of what is fraud, what is misrepresentation, difference between misrepresentation and fraud. You should be aware. Fraud is more serious compared to misrepresentation. You should mistake. Mistake is two type: mistake of law, mistake of fact. Hmm? Mistake, something that happened without intention is called mistake. Something wrong happened because without intention. You can go through that. quasi contract, contingent contract, termination of discharge of contract. We'll discuss. Quasi contract, what is it? An agreement or a contract having some features of a contract is called quasi contract. Contingent contract. What is contingent contract? You will be aware of insurance and all. These are all contingent contract. On the happening or not happening of an event, some contracts will be entered. So that is called contingent contract. This is one of the most important chapters, concept of this chapter, discharge of contract. When can a contract end? When will the contract will be completed? Hmm? What will make a contract to end? This different modes of contract by performance, discharge by performance, discharge by agreement, discharge by lapse of time, discharge by operation of law, discharge by impossibility of performance, discharge by breach of contract. So to make it understandable, discharge by performance. Suppose Mr. A enter into a contract with Mr. B, and whatever conditions in the contract has been satisfied through performance, that the contract has been concluded. Discharge by agreement. Suppose a contract has been entered between Mr. A and Mr. B, and later another contract has been entered saying, even though the performance has not been completed, let us enter into another contract saying that first contract has been completed. So, discharge by agreement. An agreement to conclude the contract. That is by discharge by agreement. Discharge by lapse of time. So, in some contracts, there will be minimum time stipulated for completion of contract. You will be knowing this in road construction contracts and all. There will be minimum time stipulated in the contract itself. Suppose if the contract could not be completed by that time, it is called lapse of time. Because the time is over, contract can be discharged. Discharged by operation of law. Sometimes Mr. A and Mr. B enter into a contract. Mr. B died after some time, so that contract is not enforceable. Because of that operation of law, contract can be discharged, or that person can be insolvent. Because of some reason, because of operation of law, it is called operation of law. Because of the lawful reason, it cannot be completed. Discharge by impossibility of performance. Sometimes when a party enter into a contract and later on that whatever the contracted entered matter become impossible to perform, it may so happen. Suppose Mr. A and Mr. B enter into contract to complete something within 1 week, and next day government imposed lockdown, and it is impossible to get out of house. Because of impossibility of performance, contract can be discharged. Discharged by breach of contract. So Mr. A and Mr. B enter into contract. So if suppose Mr. B did not comply with the conditions of the contract, Mr. A can say Mr. B has breached the contract. Because of breach of contract, Mr. A can conclude the contract. So this one should be very well aware. Okay, different modes of discharge: discharge by performance, discharge by agreement, discharge by lapse of time, discharge by operation of law, discharge by impossibility of performance, and discharge by breach of contract. Minimum, you should be aware of these things. These big words, you don't become afraid. Okay, novation means what? Mr. A and Mr. B enter into a contract to do something, and next day Mr. A enter into contract with Mr. B saying, I will give you 100 rupee. Mr. B enter into Mr. C contract with Mr. C saying, I will give you 100 rupee, but on behalf of me, Mr. A will give. So first contract become concluded because of the entering of next contract. So when a fresh contract is entered in place of an old contract. That is called novation. Another important topic: what difference between contract of indemnity and contract of guarantee? This is a possible question in exam. One should be very well aware. Okay, minimum points you should be aware of this. Indemnity means insurance kind of thing. Guarantee I will discuss. We'll discuss what is the difference between contract of indemnity and contract of guarantee. Indemnity, there will be two people: indemnifier and indemnified. Guarantee, there will be three people: debtor, surety, and admin person. We'll discuss that in detail. So I suggest for a minimum, you should cover this one table to cover the topic. Minimum, if you cover this, you'll I can say you are a little bit safe. So what is an indemnity and what is a contract of indemnity and what is a contract of guarantee? In contract of indemnity, there are two people: indemnifies and indemnified. You suppose you enter into a life insurance or a health insurance contract with some insurance agent. So you will be the indemnified and the company will be indemnifies or indemnifier. This is not FICE, indemnifier. Okay. Insurance company is indemnifier. You are indemnified. There will be two people in a contract of indemnity. What is contract of guarantee? There will be three party: principal, debtor, surety, and creditor. So let's discuss what is a contract of guarantee. Suppose Mr. A give 10 rupee to Mr. B. Hmm? So Mr. A is creditor, Mr. B is debtor. Suppose Mr. will not give that money back to Mr. A. So Mr. A wants some guarantee, no? So he will appoint Mr. C saying, suppose Mr. B is not giving me money, Mr. C should give. So here Mr. C is the surety, Mr. B is the debtor, Mr. A is the creditor. You can just go through the definition, you will be able to define that. More important thing is to make you understand the concept. In a contract of guarantee, there are three people: one who give the money, one who receive the money, and another person who will guarantee that if the person who borrow did not pay back the money, I will pay. That is called surety. So in the contract of guarantee, there are three people. In contract of indemnity, there are two people. Okay. So this is a tactical way of writing examination. So you say here there are two people. Here there are three people. Here you will say there are two people are this indemnifier and indemnified. Here you can say the three people are so and so. So also you can say primary responsibility is on the indemnifier, like insurance company. The principal liability, the more liability is on principal debtor. In case of liability, here principal liability is on the indemnifier. Here it is on the principal debtor. Indemnifier is not acting on behalf of the debtor. Surety give contract at the request of the principal debtor. In a contract of indemnity, there is no concept of surety. Here, surety works on behalf of principal debtor. So you can go through the table. You can understand the concept. More importantly, if you understand the concept, you will be able to bifurcate. And the one important thing, what I suggest to my students is never, if you are not sure, never ever mention the section. Unless you're 100% sure, never mention the section in the answer sheet. Why? Because even if you mention everything correct in an answer sheet, and if you mention wrong section, you will not be able to score a single mark. If that is a professional exam you're writing. Trust me. Quotation of wrong section will give you 0 marks. So unless you're 100% sure, never mention the section. You can use the word as per the relevant sections of so and so act. So another kind of questions that can come in the exam is rights of surety. These are all, see, you can think. Suppose I told you here, there are three people: principal debtor, principal creditor, and surety. These people are having rights, no? What will be the rights of principal creditor? A person who give money has the right to receive money. If principal debtor is not giving money to creditor, he can ask surety to pay. So these are all rights of creditor. What will be the rights of debtor? He once he receive money, he has the right to appoint surety. In the event he is not have paid the money, he can ask surety to pay the money. He can ask creditor to comply by the conditions of the guarantee. So, what are the rights of each people? That also one should be aware. So, you can go through the rights of each party. So, when will the contract of guarantee will be completed? By giving notice, by death, by see, these are all you will be able to identify here. Previously, also we discussed discharge by performance. What are the method through which a contract can be concluded? So, like that, same you can use the same points you can use here if you understand the concept. So, most important thing is understanding the concept. See, when a single person is giving guarantee to make payment, that person is called surety. Whereas there more than one person, that is called co-surety. Another important topic, bailment and pledge. Difference between bailment and pledge is a possible question. It has been repeatedly asked. So, what is bailment? What is pledge? We'll discuss. So, different kind of question can come. Rights of bailer. What is but rights of bailee? So, let's understand what is bailment. Bailment as the delivery of goods by one person to another for some purpose upon a contract that they shall, when the purpose is accomplished, be returned or otherwise disposed of according to the directions of the person delivering the bailment consists of bailer and bailee. So Mr. A bought 100 rupee from Mr. B. So Mr. B asked, I am giving you 100 rupee, but I want some guarantee, no? That suppose you are not giving money, what will I do? So he gave the key to his car. Mr. A gave key to his car to Mr. B. That is called bailment. So, delivery of goods for some purpose. Upon that 100 rupees returned to Mr. B, Mr. A can take the car key back. So, who is a bailer? The person who deliver the goods. Mr. A is a bailer, Mr. B is the bailee. A person who deliver the goods. What is bailment? For some, as per the contract, to complete the till the completion of the contract, as a guarantee, Mr. A give his car key to Mr. B. So Mr. A is bailer, Mr. B is bailee. Once the payment is completed, B will give key back to A. Hmm. So what will from this point, if you understand the concept, there will be rights. What you can say, what is the rights for Mr. A? What is the rights for Mr. B? So Mr. B, suppose, what are the rights? He has the right to retain the possession of the car until his payment is received. Mr. B has the right to receive the money he paid. He is paid. Suppose Mr. A has not paid back the money to Mr. B, he can sell the car and claim the money and give the back to Mr. Balance money to Mr. A. What will be the rights of Mr. A? Mr. A has the right to receive his car key once the payment is completed. Mr. A has the right to receive balance amount once the payment sale of car has been done because of the failure of payment. His balance payment, he has the right. So, like this way, what are the rights of bailor? What are the rights of bailee? You should be aware. Okay. Here and all, you can use your imagination and understand what are the his rights and responsibility. More importantly, you should be able to compare that with pledge. That is more important. So, what is the difference between pledge? What is a pledge? Bailment of goods as security for payment of a debtor performance of a promise is called pledge. So, what is the difference between pledge and bailment? It is very simple. In bailment, there can be movable and immovable goods. In the case of pledge, there will be only movable goods. There will be two party in a case of pledge, owner and pony. Bailor in case of a pledge is called owner. Bailee in case of a pledge is called bailee. So, blood. What is the difference between bailment and pledge? Pledge only movable. A pledge is a bailment. Bailment, pledge is also a bailment, but bailment will be regarding movable property only. That is the main difference. I would suggest my friends to go through this. Okay. Defines a pledge to be the bailment of goods as security for payment of debt. This security for payment of debt. This is the key word. Okay. You should be able to recreate this word in the examination paper. Defines as a pledge as the payment of goods as security for payment of debt and performance of a promise, whereas Section 148 provides that a bailment is the delivery of goods by one person to another for some purpose upon a contract that they shall, when the purpose is accomplished, be returned to other disposed according to the directions of the person thereby they are delivering them. So, what is agency? So you'll be aware of so many agency. Is that agency? No. So you are CMA students, right? You will be having some articleship. So in that articleship, it is called agency. There will be one boss now. He is called principal, and you will be called agent. What is an agent principal relation? What are the rights of agent? What are the rights of principal? To be simple, we can conclude like this: whatever the actions of agent, principal is liable. Hmm? An agent work on behalf of a principal. Okay. Agent can give his work to another person. He is called sub-agent. When can the agency be terminated? Same as before. You can go through this simple only. Rights of principal, rights of agent. These two things is more important. Okay, in this concept. What are the rights of a principal? Provide that if an agent deals on his own account in the without first obtaining the consent of the principal and acquainting him with the. So suppose an agent, without obeying the instruction of principal, acts something and do something wrong. So principal is covered from any legal further repercussions. So if agent work in dishonest or without the correct directions of a principal, then principal is safe. That is the right of a principal. What is the right of an agent? This is very important. Okay, rights of principal and rights of agent. Rights of an agent that agent may retain out of the sum received on account of the principal in the business of agency all money due to himself in respect of advance made or express properly incurred by him in conducting such business. Also, some remuneration as may be payable for him, such as an agent. So he is liable to receive remuneration. So if not paid, he has the right to claim that amount. Same again, it is repeated. You can go through that. Most importantly, Agent is covered. Even something wrong happen, always principal is covered. Principal is primarily responsible even for the act of agent. Unless agent acted in fraud or misrepresentation, principal is always liable. So this is a quick revision of chapter number 2. In the course of this chapter, I have mentioned some important topics. One should always cover that topic more importantly. And once this lecture is over, I'll be uploading another video regarding the most important question that can come from this chapter. If you watched both the video, you will be having a fair idea regarding the important topics of this chapter. If you are able to cover these portions, there is a high probability you will be able to perform well in the exam. And also, as I told in the beginning, portions which has not been discussed also are possible that question can come from that portion. But considering the previous year question papers, these are the most important or frequently asked questions. Thank you for watching.